The Johnny Depp-Amber Heard trial was watched by millions and millions of people all around the world. And late last week, Johnny Depp was awarded a $15 million judgment against Amber Heard. So we started thinking, what does that mean if it was all done in Canada? And if Amber Heard filed for bankruptcy to try to avoid paying that judgment. So today's Brandon's blog is titled Defamation to Character, the bankruptcy information you need to avoid paying a Johnny Depp-Amber Heard expensive judgment. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. The blog Brandon wrote researched what would happen in Canada if Amber Heard had that defamation judgment against her. She was Canadian and she filed for bankruptcy under the Bankruptcy and Insolvency Act, Canada. Brandon first goes through, in general, what is defamation, how it works in the real world, and then goes into the various aspects of it, including some key bankruptcy decisions that have been made dealing with harm inflicted through various means, either through defamation, through cyberbullying, or in one case, surreptitiously taking photographs and videos in the washroom of the employer without the employees knowing about it. And we looked into, would such a defamation claim survive if Amber Heard, as a Canadian, filed for bankruptcy? And the answer is maybe and maybe not. And here is why. It all comes down to section 178(1)(a)(1) of the Bankruptcy and Insolvency Act, Canada. And it reads, any award of damages by a court in civil proceedings in respect of bodily harm intentionally inflicted or sexual assault or wrongful death therefrom. That's what it comes down to. Brandon reviewed 3 cases. They looked at this specific issue, both in a defamation and cyberbullying scenarios. And it comes down to, is bodily harm intentionally inflicted? And the cases say that bodily harm does include a verifiable mental health condition. So bodily harm can be physical or mental health. And if it is intentionally inflicted, then it falls under the category of debts that are not released by an order of discharge, which means that a defamation claim where in the civil court the finding was it inflicted bodily harm that was intentionally inflicted, that claim, in this case the $15 million, would survive the person's bankruptcy and would not be eliminated on their discharge from bankruptcy. However, if the harm was not intentionally inflicted, then the claim would be caught in the bankruptcy and would be eliminated when the person got their discharge from bankruptcy. So that is the determining factor as to whether a defamation claim that has been adjudicated in the civil courts and an award was granted, whether or not that claim would survive the person's bankruptcy. I hope you can read the entire Brandon blog below, because I know you will find it informative and it is full of very good information in this very distinct area of Canadian bankruptcy law. Again, both Brandon Smith and myself are available at any time to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you.